Welcome. Today's video will cover how to request an administrative determination of inapplicability, or how to change the status of a rental unit. This workshop will cover four main topics. First, it will define an administrative determination and what change of status means. Second, it will explain the burden of proof. Third, it will explain the four different types of forms and what each seeks to accomplish. And finally, we'll show you how to submit the paperwork. Before one can understand the administrative determination process, one must first understand the underlying regulations that creates the process. The Richmond Rent Ordinance requires that all rental units enroll with the Rent Program. Once enrolled, rental units are designated a certain status. Units are either fully covered or partially covered. Fully covered means that both the rent control and the just cause regulations of the Rent Ordinance apply to the unit. Partially covered means that only the just cause regulations apply. Each status has a different level of annual fee attached. If neither portion of the rent ordinance applies, then the unit is exempt, and no fees should be charged. The administrative determination is the process by which an owner may request that either the rent control regulations or the just cause regulations do not apply to the unit. If granted, the status of the unit would change. This creates an exemption. The exemption changes the status of a fully covered unit to either partially covered or completely exempt, or it may change the status of a partially covered unit to completely exempt. All claims for administrative determination for exempt status will require a minimum of two types of documentation: the correct rent program form and evidence to support the claim. All claims place the burden of proof on the applicant. The burden of proof means that the applicant must provide enough evidence of their claim to convince the administrator of its validity. The applicant must prove two things. First, that they are the owner, and second, the validity of the change in status or exemption request. To prove ownership, the applicant must provide a copy of the recorded grant deed. A recorded grant deed is issued by Contra Costa County and is the legal record of ownership. When proving ownership, there are two common questions that arise. Questions regarding unpaid back fees from the period before the current ownership began, and questions regarding multiple owners. Regarding the first question, owners may only apply for exemption for the time periods that they are the owner. When a property is sold, a new owner may not retroactively request exemption on behalf of the previous business owner. A new owner does not possess the authority to request the rent ordinance to be inapplicable for the previous business owner. This means that any unpaid back fees transfer and become the responsibility of the new owner. The fees cannot be exempted or waived. Second, regarding multiple ownership, ownership is defined as a 50% share of the property. In cases where there are multiple owners, at least 50% of the ownership must be recorded on the grant deed and be party to the administrative determination application. An application with a share of ownership of less than 50% does not have the authority to request rental unit status changes and will be denied. The second thing the applicant must prove is the validity of their claim as to why portions of the rent ordinance do not apply to the rental unit and any tenants. The Rent Program created 4 different forms to accommodate all claims. The forms themselves are very simple and only ask for basic information, such as names, dates, and signatures. The bulk of the claim is made in the provided evidence. The first form is called the Request for Administrative Determination of Inapplicability due to owner occupancy. This form would be used to request either a fully covered unit or a partially covered unit to be made completely exempt because the current owner occupies the unit as their primary residence. Owners may claim current exemption and/or exemption from past fees assessed. To prove owner residency, rent board regulations require proof that spans a 4-month period. Proof may be anything that demonstrates residency. Examples include utility bills for the unit addressed to the owner residing at the unit, a driving license, tax documents, and post office change of address forms. To meet the burden of proof, this evidence should be 4 consecutive current months of documentation. If there are owed back fees that the owner wishes to claim exemption from, the owner's proof would need to demonstrate not just current owner residency, but also owner residency for the years in which they are seeking exemption. Generally, for consecutive months of documentation from the start of the owner residency and 4 consecutive current months of documentation, which creates bookends of evidence, is sufficient to meet the burden of proof. The more documentation provided, the more successful the applicant will be in demonstrating the validity of their claim. The second form is called the request for administrative determination of inapplicability due to the unit not being available for rent or due to the tenant living rent-free. This form would be used to request either a fully covered unit or a partially covered unit to be made completely exempt because the owner is not receiving rent from the unit. To understand whether or not to use this form, the owner must understand the legal definition of rent. Rent is defined as all periodic payments and all non-monetary considerations. This definition means that anything that benefits the owner, including labor, tax payments, mortgage payments, and property maintenance, will be considered rent. Given this definition, there are 2 possibilities of when an owner is not collecting rent for a unit. The first is when the unit is not available for rent. It is the burden of the owner to define what that means and to provide evidence. A simple example of a unit not being available for rent might be when a unit is undergoing major renovations. As proof, the owner could provide the building permits or a contractor's scope of work. Whatever the claim, the evidence should support it and the requisite time periods. The second case of when an owner is not collecting rent for a unit is when the unit is occupied, but the landlord collects no rent from the tenant. A simple example might be when an owner's family member lives rent-free. As proof, the owner could provide a notarized statement from the family member stating that they do not pay rent or perform labor in lieu of rent. As with the other claims, the evidence should demonstrate the claims and the requisite time periods. The third form is called a request for an administrative determination of exempt status. This form would be used to request a fully covered unit to be made partially covered or a fully covered unit to be made completely exempt. It may also be used to change a partially covered unit to completely exempt. This form is most commonly used when a legal condition surrounding the property is created or changed. A simple example might be when a fully covered unit is turned over and is rented to a Section 8 tenant. Section 8 tenancies are partially covered, therefore, the unit status would change from fully covered to partially covered. As evidence, the owner would provide the housing assistance payments contract. The final form is called the petition to determine exempt status. You would use this form if you filed an administrative determination and your change of status was denied. You may file this petition to appeal the denied determination. After receiving the denial, you would have up to 30 days to file your petition. The petition creates a hearing, and the Rent Program's hearing examiner would act as the judge. Please note that appeals are less about the evidence of the matter, and more about objecting to the way the law applies. An appeal argument should provide reasoning for and evidence of as to why the law was incorrectly applied in the determination. If the denial was for lack of evidence or incomplete forms, then there is no need to appeal. You may simply file the original administrative determination a second time, but now adding sufficient evidence. Once the applicant has filled out the correct form and gathered their supporting documentation, it just becomes a matter of filing the paperwork. All submissions can be filed either in person, through the mail, or via email. Once we have your submission, then the property will be marked as under review, and it will be assigned to a rent program administrator who will make the determination about the change of status. Properties under review do not accrue late fee charges or other penalties. Once having made the determination, the administrator will write their findings and send a copy to the applicant. Thank you for taking the time to learn about the process of changing the status of a property and how to request administrative determination of inapplicability. If you have any more questions, please feel free to call us or visit our website and make an appointment. This concludes our workshop, and I hope you have a wonderful rest of your day.